Hi, and welcome to Module 5, Tort Liability. Our word for the week is inter alia, and it means among other things. So sometimes in a case, a judge will use this. I'll give you an example. He might say, the teacher failed inter alia to provide reasonable care upon arrival, which means that the judge is indicating that there were other things that he could have listed that the teacher had done wrong. So it sort of means like etc., but he's not going to list them all. So let's take a look at torts in public school. Tort liability is one of my favorite aspects of the law, and it's primarily driven by case law. So this isn't a situation where we're looking at the Constitution or anything like that. What you're really going to find is in cases where maybe teachers or school leaders got into trouble because they failed to provide a standard of care. One thing you'll notice is that tort cases can be very unpredictable, and that's because they often go to a jury, and the plaintiff in the case is sometimes a very young child or a very vulnerable, a student of a very vulnerable population who's had some harm done to him or her, and the jury tends to be very sympathetic. In tort cases, the awards can be very small or enormous. Now, to start off, I want to tell you that as a school leader, you would have the responsibility, or you have the responsibility to provide a safe place to go to school for students and for employees in the schools and for visitors to the school. So there's a lot of ways school administrators need to keep his or her eye open for ways that people might become injured. So for example, if someone loses their job over rumors being spread, or has terrible loss of reputation, or suffers some kind of emotional harm. Hi, and welcome to Module 5, Tort Liability. The vocabulary word for this week is inter alia, and it means among other things. And courts sometimes use it in cases when a judge says something like, I'll make up an example, the teacher failed inter alia to provide reasonable care upon arrival. This means that the judge is indicating that there were other things that he could have listed that the teacher did wrong. It's sort of like an etc. So let's take a look at torts and public school. Torts and liability is one of my favorite aspects of the law because it's driven primarily by case law. So this isn't a situation where we're looking at the Constitution or anything like that. You're going to follow, as you follow cases, you'll see that maybe teachers and school leaders got into trouble because they failed to provide a standard of care. Or you'll notice that cases can be very unpredictable, and that's because tort cases often go to a jury and have a plaintiff who sometimes is a very young child or a student from a very vulnerable population who's had harm done to him or her. So the jury is typically sympathetic. So awards in tort cases can be small to enormous. So it's an interesting aspect of the law. So remember, as a school leader, you have the responsibility to provide a safe place to go to school and to work for both children in the school, for employees, and even for visitors to the school. So there's a lot of ways that administrators need to keep his or her eye on the safety of the building and the culture and the environment to keep everybody safe from harm. So there's three kinds of torts. The first is called intentional interference, and it has two subsets. The first subset is an intended physical act that causes harm, such as an assault. Now, there are a lot of school law cases about assault. There aren't a lot of school law cases about assault, although, of course, there are some. The other subset of intentional interference is defamation. Defamation is false information that somebody spreads through speaking or spreading gossip. That's called slander, or through writing, which is called libel, right? So for a person to bring a lawsuit against another for defamation, they have to prove three things to be true. First, they have to show that the statements that the person made were false. So you have done something and it's really true that you didn't do it, or you just don't like somebody writing about you, but it's true what they're writing. You don't have a case for defamation. To be defamation, statements have to be false. The second thing is a person who's spreading the information, the misinformation, has to know that it's false or has a reason to know or should have known that it was false. They didn't check all their facts. So there is some responsibility of the person spreading the information to find out the facts. The third thing is that the person bringing a lawsuit has to have sustained some harm. So for example, if someone loses their job over rumors being spread, or has a terrible loss of reputation, or suffered some kind of emotional harm, that a person might have a case to sue for defamation. So notice that with intentional interference, our first type of tort, whether it's through physical actions or through words or the common feature here is that it has to be intended or intentional. The second type of tort is called strict liability for school law. For example, this is when a person responsible puts a child or a subordinate in a serious situation that a reasonable person would have known would likely cause harm. There's a somewhat recent case where a teacher took students on a ski trip, remember? And then he took them off the trail that was marked as being closed and dangerous. But the teacher led the students on that path, and there was an avalanche, and students died. And in that case, the teacher put the students into a harmful situation and should have known better and should have acted as a reasonable person. Now that's an example of strict liability. So in that case, the lawsuit would probably be filed on what's called a strict liability tort case. A couple of other examples might be bringing wild animals to school without having some real security of safety guidelines on how that's to be handled or things like that. So there are not a lot of strict liability of cases in schools, but there are some, as I just pointed out. The third and most common type of tort for schools is negligence. And this is when a school employee fails to provide the expected standard of care either for the children in the school or again for employees or again for adult visitors to the school. Now remember that for teachers or school leaders, we have in loco parentis. Remember that? So responsibilities for children. So that means it's our responsibility to make sure that we provide a safe environment that keeps all children safe. So there are a few things that must be present for a legal finding of negligence. There's 4. First is duty of care. In other words, did that person have a responsibility to care for the person who was injured? So in the case of the teacher and a child at the school, the answer, of course, would be yes. If it's a school leader and he's supposed to be watching out for the safety of an employee or children, the answer would be yes. That is the duty of care. The second is, was there a breach of that duty? In other words, did the responsible person fail to give a standard of care that would be reasonably prudent, that any reasonable, prudent person would expect? So if the answer is yes to that, then the teacher didn't make sure that his child was in a safe environment, or the principal didn't make sure that his employee was being protected, then yes, there's a breach of duty. The third thing that must be present is a link, remember, a nexus between what happened to the person and the breach of duty. So let's say, for example, the kids are out on the playground and the teacher runs inside for a minute and shouldn't have left the children unattended. And see something happened on the playground that was way out across the field, and they wouldn't have been able to get to the student and tell them to stop or to help them so that they didn't get injured. The judge might say there's not really a lot of causation there, right? Yes, the teacher should have been outside. Yes, the teacher should have been on duty, but there's a good chance that even if the teacher were on duty, he or she wouldn't have been able to stop the action anyway. So that's kind of an interesting aspect of negligence. The fourth is there has to be harm. Did the person who brings the case suffer some harm? Now, sometimes parents could say, well, my child could have been hurt. Yes, and the principal might talk to the teacher, or the superintendent might talk to the principal about what they should do, right, in the future. But you couldn't be sued for negligence unless there's actual harm. Now, remember that harm can be either physical or psychological. For psychological harm to occur, if you weren't, like say you weren't keeping students safe from things like bullying or safe from harassment. So that could involve employees, it could involve children, but there has to be some real harm for a successful negligence case to be brought. So 4 things are that a person has to have a duty of care, They have to have breached that duty. There has to be causation between the actual breach and the harm that occurred. And there has to be actual physical or emotional suffering. So negligence cases occur, inter alia, remember, and among other things, when children get hurt, typically in school, and that's when they're not being supervised and the teacher wasn't watching or went to talk to another teacher and they weren't in the classroom and they could have stopped the action. And it could be because there was something in the building that wasn't safe and the building wasn't maintained safely. The stairs weren't fixed, the railing, we knew it was broken, but we didn't get it repaired, right? When children were not getting proper safety instructions in the lab. Are teachers making sure that children know the safety rules? Are they following them? Things like that. It's usually cases that bring negligence. It's usually cases like that bring negligence. But remember, it can also be related to harassment or bullying. So you have to have a safe environment emotionally for children as well as physically. Now, one good thing for teachers is the judges realize that teachers and school leaders can't be everywhere all at once. And they also can't always predict sporadic, enthusiastic action of children that might cause harm to one another. So don't expect that every accident that happens in schools is the result of negligence. They understand that teachers may have 20 to 30 students in a class and they're trying to set up an safe environment. They can't be everywhere at once. So don't get overly panicked about negligence, but always take the proper steps. And I want to say particularly when you're putting children in a dangerous situation, for example, if you're a lab instructor, or taking students on a field trip, or anything where students might not be familiar with their surroundings, take extra steps to be sure they know the safety rules and that you practice some things with the children. Judges, by the way, will be also checking out other factors like when they rule on a case, or if it goes to a jury, how a jury might rule on the cases. What was the child's age? So would a 12-year-old be expected to know better than a 5-year-old? And the answer might be maybe yes, right? So the teacher shouldn't put that 5-year-old in that situation, but maybe could put the 12-year-old in it. So it kind of comes down to the judge and jury that they're going to think about what would a reasonable person do with a child of this age in this situation to prevent the child from being in any situation that causes harm. Okay. Now once you start looking for cases, tort cases, you're going to find them everywhere. When a lot of times you're going to find yourself thinking, now what was that teacher thinking, right? Because often tort cases make it to court. You won't believe the level of disregard for care. Okay. So that's it for tort law. I find it really interesting, and I hope we have some spirited discussions.